Good afternoon, everyone, and welcome to Legal Update Live. Today, we're going to update you on the class action lawsuits and specifically the proposed settlement agreement that NAR entered into that tries to address some of the litigation involving home sellers in the antitrust class action lawsuits. Before we begin, just a few housekeeping items. If you have questions, please place the questions in the chat. Only presenters will be able to see the questions, and we will not be responding to your questions via the chat, but we'll be answering the questions at the end of the presentation. And we are going to try to answer everybody's questions. So we have an hour scheduled, but we are planned to go longer to see if we're able to answer the questions. Now, there may be some questions that we're unable to answer. We are going to be giving you the information that we have based upon what we've seen and what we've heard from NAR, but you may be asking questions that we're just unable to answer at this time. So if that's the case, we'll let you know. If by chance there's so many questions that we're just unable to answer them, we'll let you know that too, and you can submit those questions through the legal hotline. So the settlement agreement was entered into just 2 weeks ago. Seems longer than that. It's actually 2 weeks from last Friday. And this proposed settlement agreement is supposed to end the litigation claims brought on behalf of home sellers related to broker commissions. Now, this is only involving the antitrust lawsuits involving home sellers. There's another series of lawsuits involving home buyers that this proposed settlement agreement does not address. And the first word is probably the most important word. It is a proposed settlement agreement. It has not been finalized yet. It is still subject to court approval. NAR is going to be submitting the proposed settlement agreement to the court within the next week or two. And then the court has, NAR is estimating probably by the end of December to decide whether or not to finalize that agreement. Now, the agreement has a deadline for the changes, and the NAR is anticipating that the deadline will be July 2024. And the reason why they don't have an exact date yet is that the date is 120 days from the date in which they file the proposed settlement agreement. And they are hoping to do so by early April. And that date's been pushed off every week that I talk to them. So they're hoping that it's going to be in early April. And then they'll have 120 days, which is approximately the end of July. The other key element to this agreement, and maybe one of the most important elements, is the fact that the DOJ has not signed off on the proposed agreement. Now, we anticipate that NAR has reached out to NAR or reached out to the DOJ and tried to get the DOJ's feedback on the proposed agreement. But that's not how the DOJ generally operates. I'm sure they're reviewing the agreement and seeing whether or not it addresses their concerns with respect to transparency. Remember, DOJ from the beginning has wanted to make sure that the commission process is transparent, that consumers are aware that they have the ability to negotiate the commissions, that they have the ability to understand who is paying the commission and how much the commission is and what is being done in exchange for the commission. So watch for the DOJ to weigh in at some point, and that could maybe change some of the provisions that NAR has included in the proposed settlement agreement. So there are 5 key elements to the settlement agreement. The first is a settlement amount in which NAR has agreed to pay $418 million over 4 years. Now, we've gotten a little bit more information from NAR as to exactly how that's going to be paid. They've indicated that $5 million would be paid within 30 days of the filing of that proposed settlement agreement, and then $170 million within. I'm sorry, it's $5 million within 30 days after the agreement is approved. by the court, which again we're anticipating will be the end of December, and then 170 million within 90 days after that approval, and then they would pay $72 million for the next 3 years after. That's again still subject to court approval, but that's what's in the proposed settlement agreement. In addition, as we mentioned, the agreement is to be approved by the federal court. And there are two main substantive changes within the proposed settlement agreement. The first is some changes to the buyer agency agreements, and the proposed settlement requires all MLS participants working with buyers to enter into a written representation agreement with their buyers. And we're going to go into a little bit more detail on these provisions, but wanted just to highlight what those provisions were. The second substantive provision deals with offers of compensation. And this is the one that has probably the most questions associated with it as to how it applies in Wisconsin. And under that provision, NAR has agreed to a new rule that prohibits offers of compensation on the MLS. The last key provision is that as part of this settlement agreement, NAR agreed that they had not engaged in any wrongdoing whatsoever. So now we'll go into a little bit deeper dive into some of these key substantive provisions. The first one, as I mentioned, is the buyer agency agreement. And this one says that the buyer agency agreement must be in writing and must be entered into before touring a home with a buyer. Several of you have asked, so how does this affect open houses, and how does this affect subagents that may be showing a home to a property? The only thing that we can tell you is that there's a provision in the proposed settlement agreement that indicates it does not override state law. So if that is true, and if it's true, we mean that we have not heard anything to the contrary from NAR. But if that's true, it doesn't override Wisconsin law. So Wisconsin law would still apply and still guide in these types of situations. The other key thing to remember is that the seller concessions can continue to be offered on the MLS. And we're often asked, if we had a crystal ball, what do we think that the DOJ may look at or may ask for some changes to? And DOJ may look at the fact that this applies to MLS participants only and may ask for something a little bit broader, that applies to all real estate licensees engaging in a transaction. We don't know for sure, but just kind of a suspecting on our part that the DOJ may look for some rules that apply to a broader group of practitioners. The other key provision is offers of compensation. Now, this prohibits offers of compensation in the MLS, and it applies broadly to the MLS. So we've heard in some parts of the country licensees wondering on social media whether or not there are workarounds on the MLS, whether it could be provided in some of the showing services. And the language is pretty clear, and we've had conversations with several of the Wisconsin MLSs that it applies broadly to the MLS. That means it can't be posted on the MLS anywhere. The other thing we want to mention is that please don't engage in discussions trying to find workarounds on the MLS, especially in social media. Assume that the DOJ has access to these conversations, and it could really affect the settlement, the proposed settlement agreement, and it could cause the DOJ to weigh in further and make additional changes to real estate practice. There is nothing that prohibits seller concessions from being offered on the MLS. There is just a prohibition on offers of compensation in the MLS. The other thing that we do know is that realtors can display on their own website offers of compensation for their own listings. So who is covered by the proposed settlement agreement? The settlement agreement covers real estate brokerages owned by realtors that had a residential transaction volume in 2022 of $2 billion or below. It includes all realtors not affiliated with Home Services of America. So even if you have a real estate brokerage that has a transaction volume above $2 billion, the settlement would still cover all of the agents that are associated with those brokerages. It also covers NAR and all state and local realtor associations. Finally, it covers all MLSs that are wholly owned by one or more realtor associations. Now, that was a very important provision because I know several MLSs were talking about whether to decouple from the realtor organization. And they were looking at a wide variety of considerations when deciding that. And every MLS that we're aware of in Wisconsin is a realtor-owned MLS. And so all of the MLSs in Wisconsin should be covered by this proposed settlement agreement. So this leaves us with who's not covered by the proposed settlement agreement. Obviously, all non-realtor brokerages and their agents would not be covered. All real estate brokerages with a residential transaction volume in 2022 of more than $2 billion would not be covered. All agents and employees affiliated with the Home Services of America and its related companies are not covered by the proposed settlement agreement. Employees of the remaining corporate defendants in the Gibson and Oompa cases. Now, these are two cases that were filed in the Western District of Missouri. The Gibson case was filed by the exact same attorney in the Sitzer-Burnett case on the exact same day that the verdict was handed down in the Sitzer-Burnett case. And the Oompa case is another seller antitrust class action lawsuit filed in the Western District of Missouri. So any employees of the corporate defendants in those two cases would not be covered. Lastly, any MLSs that are not wholly owned by the Realtor Association would not be covered by the proposed settlement agreement. Now, I'm going to turn it over to Jennifer to discuss some of the impacts on buyers and sellers and realtors in the state of Wisconsin.
Thanks, Tom. Hi, everyone. I am going to talk a little bit about the impacts on home buyers and sellers, and then a little bit about how this affects your practice in Wisconsin. But first, for the home buyers and sellers, one of the goals was to create more transparency for buyers and sellers, and certainly this discussion goes a long way to do that so that the parties better understand how commissions are earned, how commissions are paid, if there is an offer of compensation, how that is arranged and what that looks like. That's one of the stated effects that we'll see on home buyers and sellers. I think, like Tom was saying, because this information is quite new and it's going to take a while to process, we might not know the full effects on home buyers and home sellers until some of these rules get implemented and we can see how that shapes the market and practice. The discussion might modify how buyers and their firms discuss how they will be paid. If the proposed settlement is approved and that MLS offer of compensation goes away, buyers' firms will have to have a discussion with the buyers about what are the options for how the buyer's firm gets paid. And frankly, that's something they should be doing, MLS offer of compensation or not. That should be a very frank discussion with the buyer about what the buyer's responsibilities are, what the options are for that compensation to perhaps be obtained from the seller or the listing firm by way of a non-MLS offer of compensation. And the settlement, if approved, does preserve choices for consumers regarding real estate services and compensation. That doesn't change. So the idea that a party, buyer, or seller can negotiate with the firm in terms of what services they want and what that compensation is going to be, that remains unchanged. So that's, again, a discussion that firms should be having with their potential clients. In terms of our Wisconsin realtors, I think it's great that we can say Wisconsin was maybe ahead of the game in terms of consumer transparency. Think about your listing contracts where that offer of compensation has been in there for a long time. The buyer agency agreement has always discussed that the buyer's firm may seek compensation from the seller or the listing firm. That's been in the forefront of our agency agreements for years. We've had written buyer agency agreements in Wisconsin for 15 years plus. This might surprise some of you, but there are some states that don't have written buyer agency agreements. We've had it for a long time now, and it's something that our agents understand. They can explain to their clients, they can explain to the buyer the value of a buyer's agent and why the buyer should consider becoming a client instead of a customer. And I mentioned this just a second ago, but our WB forms, our state-approved forms that real estate licensees in Wisconsin must use, have always had this consumer transparency at the forefront, especially as it relates to commission and the services that are available to the clients in Wisconsin. In terms of what you will continue to do, demonstrate your value in the transaction. This is something where I think agents, don't be afraid to explain what you do in a transaction and talk about it's not just putting the yard sign up, it's not just drafting the offer. You are problem solvers, and to help buyers and sellers to get from beginning to end of a transaction, you are there all along the way, looking at how do you solve problems? How do you help the parties get over the hurdles? When you're having that discussion about the value that you provide in a transaction, that's when you talk to your party about who pays the commission, how is it earned, and what services are you going to offer for that commission. Don't be afraid to connect the dots for your clients and say, you know, we charge X, Y, and Z, or whatever it is that you charge, but here's all what you can expect from us as a firm and our agents in this transaction. Nothing about the settlement created more inventory. That's still a problem. It didn't make the market less, it didn't make the market less competitive. We're still dealing with that. It didn't make transactions any less complex. That's what I was saying before about don't be afraid to discuss your value that you offer to your clients and all of the problems that you solve, that you have to help people solve as you go through the transaction. It also did not make homeownership less important for the consumer. If you worked with these transactions, first-time home buyers, second-time home buyers, sellers, whatever, you understand the value of that asset in people's lives and the value that you provide in helping them negotiate a complex transaction. Maze of paperwork, that can be an understatement sometimes. Coordinating inspections, finding contractors to make repairs, interpreting online information, reaching out to lenders, talking to the other agent. We could go on and on about all the things that you do in a transaction. So help your consumers connect the dots between the value of your services and the fee that you're going to negotiate with them. With that, I'm going to turn it over to Debbie Conrad, who's going to talk a little bit more on what the commercial aspect of this might look like.
Yes, thank you, Jennifer. This was a question that was brought to us. What's the impact on commercial practice? Is it any different than it is for everybody else? Big picture answer to that question is, well, not really. It's not really that different. I mean, I guess when you think about the release from liability that's out there and you go back to square one, this is a proposed settlement of the Sitzer Burnett, of the Morrow cases, which are home sellers that have filed these class actions about their commissions. And so the whole situation is about residential, it's about home sellers. And so if I'm a commercial practitioner, I probably have little liability exposure because I don't do that many residential transactions. So that part of it might be different. At the end of the day, though, too, the application who is covered is going to be the same, whether I'm a commercial practice or a residential practice. As Tom said before, it covers NAR. It covers over 1 million NAR members, state and local associations, realtor-owned MLSs. And then it also includes the brokerages who have an NAR member as a principal and who had residential transaction volume in 2022 of $2 billion or less. So again, if I'm a commercial practice, I probably have pretty good odds that I don't have that volume of residential practice going on. And so I have a good chance to be covered by the settlement. Looking at some of the major substantive points in the settlement, one of the first ones is that MLS participants need to have a written agreement when they're working with buyers. Well, here in Wisconsin, that feels like that's kind of a no-brainer because under Wisconsin law, if you're working with a buyer as a client, you need to have a written agency agreement. We have the WB 36 buyer agency agreement, WB 38 commercial buyer agency / tenant representation agreement, and the WB 39 tenant representation agreement. So all of those agreements are there for commercial practitioners and all of Wisconsin licensees to use. And as we know, there's been some recent changes to increase the commission transparency, try to give a little more explanation about how commissions are determined and how they are paid. And so that's all there in the WB forms that commercial practitioners who are real estate licensees in Wisconsin, they have to use them just the same as everybody else. The other major substantive point had to do with the NAR's agreement to create a rule that there cannot be any offers of compensation in the MLS. I guess a lot of commercial practitioners probably use the commercial exchange platforms, which don't make any offers of compensation. If they engage in those types of transactions, they are determining the compensation, the commission broker to broker in each individual transaction. To the extent that they do engage in transactions and there's commercial properties, and there are some on the MLS, or there's a mixed use or an apartment complex or something like that, which might be on the MLS, well, then that would impact the commercial practitioners in those situations, and they would have to do what they do for the commercial exchange platform and just deal with the compensation and negotiate that on a case-by-case basis. And I guess lastly, when it comes to the fact if our state laws end up being changed as a result of the settlement, again, the law is the law, licensees are licensees, and it would impact everyone. So in terms of commercial practitioners, they may have a little bit less liability exposure when it comes to these sellers in the residential transactions, but at the end of the day, everything else seems to apply to them just the same. So now I think it's time we're going to turn this over to Tracy, and she's going to talk about the impact on professional standards.
All right. Thank you, Debbie. So today I am looking to discuss potential implications both to professional standards, the code of ethics, and our MLSs. And I think even though we're all reviewing this settlement and we're looking at what the ripples are, there may be the devil's in some of the details, and we're working and navigating to look at how things are going to be applied. I think for right now, in terms of the code of ethics itself, I don't see a lot of things changing at this point in time. When you think about Article 1, I think Jennifer talked about it earlier. When we're entering into our agency agreements, we're explaining commission and compensation, right? Whether that's in the listing contract or it's in the buyer agency agreements. That's part of Article 1 and the corresponding standards of practice 112 and 113. So in terms of getting more transparency in transactions, like Tom talked about, like what the DOJ is all about, if we're doing what's in Article 1 and those corresponding standards of practice, we're going to be on the path to transparency and informed and educated consumers. In terms of Article 3 of the Code of Ethics, that is the article that talks about cooperation. And interestingly enough, if you look at Article 3 of the Code of Ethics, even for years and years, it says that obligation to cooperate does not include an obligation to share commissions or fees or otherwise compensate other brokers. So there's always been a separate concept of cooperation, information, access, all of that, and compensation. Now, the MLS brought those two together, and we're going to see the decoupling of that through the MLS, but we're still going to have Article 3 of the Code of Ethics saying that we're going to cooperate. It's just how are we going to go about having the broker-to-broker off MLS compensation agreements? Or will buyers and sellers be talking about that, for example, in their offers through seller concessions, right? So there's going to be some shift, but the underlying concepts that we're still going to cooperate are embedded in Article 3 of the code. Now, one of the other things in standard of practice 3.1 of the Code of Ethics, it talks about in that standard of practice that terms of compensation, if any, shall be ascertained by cooperating brokers before beginning efforts to accept an offer of compensation. So this is where when cooperation and compensation went hand in hand in the MLS, you didn't have to be asking. You could just look in the MLS, what am I being offered? Now, it's going to be an affirmative step to say, hey, listing firm, are you offering compensation? Are we entering into a compensation agreement broker to broker? Is that the way we're going to play this out? Or maybe the buyer might be paying a buyer's agent directly and there's not a broker to broker commission agreement. But having those commission agreements, being aware of what they are up front is still really in keeping with what's already existing in our Code of Ethics. The one thing that I might expect some practice changes or some case interpretations about is standard of practice 3.2, because as we transition from the MLS offers of compensation, and if the proposed settlement go into effect, We're going to be eliminating and removing those from the MLS. There might be some growing pains about the codes right now says you can't change an offer of compensation once an offer has been submitted. So we might have a little turbulence as we navigate the MLS offers of compensation to the not MLS offers of compensation. I was on a call yesterday with some folks talking about professional standards from the National Association. They are gathering questions. They are vetting them through council, running them past the settlement agreement. And I fully expect that we're going to get more insight from them as we move forward. But for us, feel free to ask us questions as well. We'll do the best we can to answer them, or send them up to the National Association to get some insight from them. The last section in the Code of Ethics is Article 17. And the interesting thing is that ever since the inception of the Code of Ethics, we've had an obligation to arbitrate and a privilege to arbitrate our contractual disputes between brokers of different firms arising out of their real estate agreements. So if you're moving from an MLS agreement to pay to a broker-to-broker agreement to pay, whether that's on a transaction by transaction basis or a standing agreement, there still is going to be that contractual agreement that would be subject to arbitration and the processes that we have set up in our professional standards system. So in and of itself, that duty and privilege to arbitrate will still exist and continue on, whether those offers of compensation are on or off MLS when they're broker to broker. One of the questions we've been asked is, does procuring cause go away? And I would say no, it doesn't, in that anytime that brokers are going to negotiate a broker-to-broker commission, if they choose to go that way, procuring cause can still be the standard of performance to earn that compensation. So I don't think that on its face, the duty to arbitrate goes away, nor are we going to see procuring cause go away. So one of the things, we do have a compensation agreement already in our library of forms, if you want to call it that, on zip form. I fully expect that we're collecting right now compensation agreements. And so I fully expect that those documents are going to be evolving and being made available to you, because again, we're all really in this together. Moving on to the MLS, the kind of big high level pictures for the MLS. Once the settlement is filed, each realtor-owned MLS has 60 days in which to decide to opt in to the settlement agreement via what is known as the Appendix B in the paperwork. And basically that appendix is setting forth those obligations that the MLS is going to undertake to be covered by the settlement. And basically, Tom talked about it a little bit before. Number one, they're going to eliminate the blanket, unilateral, unconditional offers of compensation in the MLS. They're going to prohibit broker-to-broker compensation in the MLS. They're going to eliminate those fields. And they're agreeing not to facilitate any mechanism by which the MLS participants and subscribers can do that. So basically they're saying you can't circumvent it. And so even though folks have been trying to get creative, like can we use showing services, different other kind of ancillary tools like that, those are things that are going to be not part of what the MLS can participate in. The last thing, there's going to be education materials. Please keep us in mind. We will be doing education, training, teaching, all of that. And then one thing, like some people are saying, hey, well now like if you're taking the money out of the MLS, what's going on? Well, if we just step back for a second and look at the big concepts of what the MLS is, it still is going to be a facility for the orderly compilation and dissemination of information, the offers of cooperation. It's there to enhance cooperation between brokerages and brokers. It's going to be the way that we assemble and disseminate information for real property information, for appraisers, for the valuation of real property. So those core elements of what the MLS is are going to still be with us. It's just that that one piece of the puzzle, that offer of broker to broker commission, is going to be have to be done separately and independent. So that's kind of, the WRA is here, and with that, I would say we're all navigating this together. Never hesitate to give us a call. And with that, I think I'm going to hand it off to Corey.
Well, thank you, Tracy. Just as a reminder, if you are attending the webinar and you'd like to ask a question, please use the chat. I see a couple of hands are raised. Unfortunately, we cannot unmute you. So if you'd like to pose your question, you have the entire legal team here on the webinar today to provide you as much guidance as we can relating to the proposed settlement. I would like to take just an opportunity to visit with you about how you're going to communicate this with your consumers, right? So there's been a lot of conversation. Everybody's trying to figure out what are the key points that we should be using with our consumers. And then I'll follow that up with a do's and don'ts discussion, kind of summarizing a little bit of what Tom and Jennifer had provided. So key talking points. You know that there's no standard of commission. So there's no standard commission rate. Remind them of that. Your forms now include that. Even though it was already something that everyone knew, it was emphasized in the 2024, January 1st, 2024 WB listing contracts and buyer agency agreements. So kind of keep reminding them about the fact that there's no standard commission rate. And as a reminder to them, and as to you as well, commissions have always been and will continue to be negotiable. So this isn't something that is new. It's just something that it's good to be mindful of when you're having these discussions. The changes are actually likely going to have a very minimal impact in Wisconsin. As Tom and Jennifer both indicated, we have very pro-consumer documents. Our WB forms are required for us to use. We've had written buyer agency agreements and requirements for over 15 years. So again, a lot of what may be a substantial impact in some states is not going to be the same type of impact that we're going to experience in Wisconsin, because we've already been out ahead of this consumer component. And mainly because you guys have this limited right to practice law as real estate licensees. So our forms that we're required to use balance that ability by having these state approved forms that also make sure that there are consumer protections both in those forms and the state law. So as I mentioned, you have those items in your WB forms. As Jennifer indicated, this is not changing your value as a realtor in a real estate transaction. You're still going to talk to them about how you can provide them this guidance, how you can be their voice, how you can advocate on their behalf. They've always had the option to hire a realtor or not. This is not new. You've been out there proving your value to consumers for as long as you've been practicing. So again, this is not going to change how you've been having these discussions. It may just have a little bit of a longer discussion, showing your value, explaining how you can help them with deadlines, how you can provide them assistance when we're completing forms. All of those things that we like to say, you're kind of the duck on the water, right? Up on the top of the surface, smooth and easy. Down below, you're paddling like nobody's business. I'd use a different word if it weren't a professional setting, but it's one of those things that you make it look easy and you need to remind them that it's not, and that's why you're here for them. Again, compensation, just like your commissions, has always been negotiable. It's also been something that's always been discussed and determined through negotiations with realtors and buyers, realtors and sellers. And again, while it's not necessarily going to be facilitated through the MLS, you can always have different ways. This is the proposed settlement agreement provides us the opportunity to have conversations about how we're going to be compensated. And so again, it's just pivoting a bit, but not a substantial impact. And as Jennifer mentioned, there is nothing in this proposed settlement agreement that creates more inventory. Therefore, it doesn't create a less competitive market. You have to still be there to help those first-time buyers or the buyers that have been writing offers on properties and have been pushed out for 10 offers. That skill is still there for you to provide them that guidance. It does not make the transaction any less complex. It does not make it any less emotional, and it doesn't make it any less the single largest investment that the average person makes in their life. That's what you're here for. Nothing changes that in this proposed settlement agreement. You're going to help them When someone says it's available online and you say, oh, nope, sorry, it's not available anymore. There's an accepted offer on it. That's how you provide your service to them. You know that marketplace. You understand those HOAs and the areas that you work. You understand lake associations. Those are the types of things that a real estate attorney who dabbles in this isn't going to provide them that guidance. Just like today, the proposed settlement doesn't change any of that. That's how you're going to help them. You're going to help manage those deadlines. You're going to help them understand the difference between a notice and an amendment when it comes to the inspection contingency. Those are the skills that you have continued to offer and will continue to offer under this proposed settlement agreement. But let's talk about the things you're gonna do and the things that we don't propose you do. Again, you're going to make sure that the consumer understands the commission amount. You're going to make sure the consumer understands who pays the commission. You're also going to make sure they understand how commission is earned. And Wendy, who I'm going to hand this off to in just a minute, is going to further emphasize those discussion points for you. As Tom mentioned, don't start discussing workarounds, ways that you can kind of get around this potential loophole of how can we put it in the MLS without it being, part of this proposed settlement agreement. Don't do that. It's very clear that we're not to have any sort of offer of compensation under the proposed settlement agreement in the MLS. As Tracy indicated, we've had a few different questions about maybe utilizing services where people are booking appointments online. Is that where we can make those disclosures? No, you can put your MLS, you can put your compensation out there as what you're going to offer on your listings on your website. That we know. That is the guidance that we've had from NAR. As far as the other ways that this is going to come down, we'll be able to provide more guidance as we get more information from NAR. We'll make sure to share that with you. And as Jennifer indicated, make sure you are already, and you should be, comfortable about talking about your value in the transaction. You know how to do this. You just have to make sure it's even clearer to them. So again, you know how to talk about your value. And please, as Tom mentioned, don't talk about commission rates on social media and advertisements. Focus on you, not on others. So you don't need to make generalized statements about don't use this, don't use other realtors that charge this, use me, I charge that. Just talk about yourself. Don't worry about the others. Make everybody else, they're going to all talk about their value. You don't have to do any of that. And as Tom indicated, social media is available to everyone. They can see what you're talking about, just like your advertisements. So please be mindful of that. We want to make sure, again, that we're honoring the objectives of this proposed settlement agreement. In addition to things like the legal update lives, what is WRA doing? As we've probably heard from us, we have communications. So externally, we're doing media interviews. We're meeting with lawmakers, the governor, attorney general, legislative leaders, the Department of Safety and Professional Services, whomever may have questions for us, whomever might want some guidance as to what this means. Internally with you as members, we're continuing to provide you email updates, talking points. We're going to have some magazine articles coming out. Videos will be more evident than the Legal Update Live, and presentations. As Tracy mentioned, we're here for you. We're able to come out and speak to you either virtually or in person, depending on circumstances. That's what your legal team can provide you, that guidance, and at least as much as we can, again, with the proposed settlement terms. We are also, as we've mentioned before, we already had a buyer agency work group in the mix before the proposed settlement came out. So we're looking at this as a group to try to figure out, are there statutes that need to be changed, which is that 25-26 legislative agenda that we're discussing? Are there form changes that need to occur? We're looking at amending our addenda, any of the WB forms. The hardest part, and again, while we're working behind the scenes on all of this, we're not going to take any public steps because the proposed settlement has not been approved. So that mid-July timeframe that Tom mentioned at the beginning of the discussion as to proposed settlement terms, we are mindful of that, and we are not doing anything. It's just we're not being super visible externally on this matter because, again, we have to make sure that we don't take steps until we know that this proposed settlement has not been modified in other ways. So I'm going to hand this off to Wendy. Wendy is someone that maybe you've heard her voice regularly on the legal hotline. And Wendy's going to talk to you a little bit about steps with consumers and some other resources that we provide for you. Go ahead, Wendy.
Thanks, Corey. I'm going to be talking about steps you take with consumers and how to kind of explain what's going on and how to move forward in light of the proposed settlement agreement. So as Jennifer and Corey pointed out, There is no standard commission rate, despite what has been portrayed. That hasn't been the case. So you can just emphasize that there is no standard commission. When you're going over your listing contract with sellers and your buyer agency agreement with buyers, you want to make sure that, as Jennifer and Corey pointed out, that you're explaining the commission amount and you're explaining the value, that these are the brokerage services that you're providing. This is how you're going to help the consumers navigate the real estate transaction. And that's what your fees are. And it's reflective of that. You want to avoid pre-printing the commission amount. We've had, a question before, what does pre-printing mean? So pre-printing would mean that you're including that commission amount in your contracts before even talking it through with the consumer. So as you're going through your listing contracts and your buyer agency agreements, make sure that that is still blank, that they know that it's not preset, it's not pre-printed before you even have that discussion with them. So after you go through that contract with them, then you would fill in that commission amount. You'll want to avoid portraying or even suggesting that buyers agents work for free when they don't. So, we've had questions where it's, buyer's agents work for free, seller pays. That's not the case, right? If the buyer's agent is being compensated in any way, you don't want to be portraying that the buyer agent works for free. And then with the compensation to others, again, you're just going to want to explain that, go through the listing contract with the seller and explain, this is the amount that I am offering to any cooperating firm. Again, avoid pre-printing that, avoid putting that there without having that discussion about what the offer of compensation is with the seller. We have had questions about any changes to forms. So if your firm is thinking about making any changes, you're just going to want to consult with your own legal counsel. So if you're making any changes, such as a change to an addenda that your firm has, make sure that you consult with legal counsel. And then the last thing here is make sure you're avoiding steering buyers based on the offer of compensation. You don't want to be steering buyers to listings that have a certain amount of offer of compensation. So some resources, Tracy was talking about how we want to help. So we do have a lot of resources. We have a lot of different consumer brochures that you can be sharing with consumers. We have a buyer agency brochure that kind of explains buyer agency. The Why Should a Buyer Choose Buyer Agency brochure is also a nice quick handout. It's one page. I know people don't want to be given a whole pamphlet of information. So this brochure is nice, easy, kind of explains buyer agency and the value a buyer gets when they have a buyer's agent. And then we also have an explanation of the residential listing contract. This is available on our website. We have, the link right there. If you were to Google that, you'd get there. But I think the easiest way to find it is when you're on our website. If you just search consumer brochure, it pops up. And then more resources, we have an antitrust resource page. And again, it's there at the top. But again, if you just search antitrust on our website, you'll be taken to that page as well. And we do have an antitrust FAQ document. It has been recently updated, so you'll want to review that. And then NAR has a whole host of resources. They have a similar FAQ document. They also have a couple other resource pages, and you can find that at facts.realtor and competition.realtor. And again, if you have any questions that don't get answered today, we do have the legal hotline. So feel free to submit a question online or through the telephone, and our legal team will get in contact with you. And now I think we are opening it up for questions for the entire legal team.
Thanks, Wendy. And thanks to you for all of you for submitting questions. I'm just going to address a couple of them. And I know a lot of you have asked questions about the timing of the court's approval of this proposed settlement, wondering why it's going to take to December, or if there's a chance that they could prove it earlier. Remember, all of these timelines are set by federal court rules. Once there's a proposed settlement that's filed, other parties, not just parties to the settlement, but other brokerage companies may have the opportunity to review it. They have the opportunity to file objections, and then the court has to review those objections. So there are certain timelines for filing motions and giving the court to review those motions, and then giving the parties the opportunity to respond to those motions. So once the petition is filed, NAR feels pretty comfortable that the timelines are set by federal antitrust litigation rules, and they think that end of December, mid-December is a pretty likely range of when the court would reach final settlement. So it's highly unlikely, given the set court rules, that they would decide it any earlier. The other thing that I'm going to respond to is many of you have asked for copies of these talking points. And I want to make you aware that we are going to be dedicating the next edition of the Wisconsin Real Estate Magazine to the proposed settlement agreement, and there'll be talking points in there. However, we will prepare those talking points in advance and have those to you by the end of the week here. Today's Wednesday, so we'll have those to you. I'm looking at the entire legal team, hoping nobody is too stressed out about this, but we'll have those to you by the end of the week. And just getting feedback from the legal team as to what the best way to do this is. Should we send it out by email? Should we post it on the WRA website? Any recommendations how we get the talking points out to our members in the most efficient and effective way?
I'll answer that. Yes. I think that we'll be able to place talking points on our antitrust page, which is wra.org/antitrust. We can also send a notification out in our next legal hot tips as far as the information there. And then there is a high probability that we'd be able to send an all-member email out with those talking points as well by Friday.
So we really try to minimize the number of emails we send to you, because everybody gets bombarded by emails. But in this case, we're trying to get information out to you as timely as we can. And these talking points are extremely valuable. They're valuable whether you're talking to your customers and clients, whether you're having a conversation with somebody at a cocktail party, whether you're talking to a lender. Make sure to have these talking points down, because they help us really dispel a lot of the myths that are out there, and it helps set the record straight. So we'll get those talking points out to you by the end of the week. We'll set it out to you in a variety of formats. If you don't get them, or if you need anything else, please email us. You can email any one of the members of the WRA legal team. You can email me. You can text us, whatever you need, we'll get it to you, and we'll get it to you as quickly as we can. Okay, anybody want to start fielding other questions?
So I'm going to hit two really quickly. There is actually a WRA ABR course. I see that someone's asked about that. There is going to be an ABR course offered here in the very near future. So check out our education page, and we'll be sending emails out as well. Alyssa, I see, is on the call. She might be able to provide some guidance for us as to the dates. If not, we'll be able to do that.
The 16th and 17th of May.
May 16th and 17th. So if you're looking for an ABR course, that is available there. Jennifer, how long is the CE exam going to be available, as one of the questions?
24 hours. And while I'm on here, I'll address one other thing. That somebody was asking if this is going to be recorded. It will be, and it'll be made available sometime in the days to come. So if your agents were not able to watch it, it will be available on our antitrust resources page. It's so it might just take a minute for us to get it up there, but yes, it will be available.
There are a number of questions about the VA loans. This is something that the National Association of Realtors is currently working on. I know we have a number of questions relating to the financing components, and a big concern about if buyers have to start paying out of their own pocket. What will this mean? NAR is working on this, having discussions, and you might see some new products available depending on circumstances, but the VA loan program is one that NAR has indicated that they are speaking up about and citing some concerns.
Yeah, Corey, let me just weigh in on that. NAR is talking to the VA directly, and VA wants to get this addressed. They want to make sure that their buyers, that their veterans can be properly represented. So they're hoping to announce a solution or series of solutions in the near future. One issue that seems to come up is there seems to be some confusion about whether or not companies have to negotiate on whatever their offered rate of compensation is. Nothing requires you to negotiate on whatever you think is fair compensation. So if your company establishes a set commission rate, you're not required to negotiate that off of that. You can simply tell buyer or seller that that's what you feel is fair compensation for the services you provide. And if they want to hire a different realtor, they're free to do that. But it's important when we say that commissions are negotiable, that there's no set commission rates. NAR doesn't set commissions, WRA doesn't set commissions, local boards don't, MLSs don't. So that's a very important distinction. And I think something that you'll probably have to explain to the consumer, because I think there's probably a lot of misinformation about what it means to have commissions be negotiable. I think it's clear that there can't be any fixed commissions within marketplaces, can't be agreements between different brokers. But it's important for you to be able to establish the value of your services, and you're not required to negotiate over off of whatever you think is fair.
And I see a series of questions relating to buyer customers and pre-agency and some of the potential consequences. So one of the things that is clear under the settlement is that it applies unless it's contrary to state law. So one of the things that we're trying to discern is what will happen to things like pre-agency in the state of Wisconsin. In addition, we've had a couple of individuals asking questions about now that I'm the agent and I'm a listing agent and I have a buyer come to the property after this mid-July date, what kind of documentation will I have to be able to provide to them? We're still working through some of those discussions. As Tom mentioned, it's been less than 10 days. There's still a lot of discussions because it's an agreement that applies to all 50 states. And each state, as you know, practices differently. And so the nuances are something that each state is trying to seek some clarity on with the NAR legal counsel. And a number of us have regular sessions that we're able to start getting into those questions. So we will, again, as we find the answers, we will start to communicate those to you as much as possible.
There's been several questions about the timing of the rules, and just a reminder that they go into effect in mid-July. It's based off of when NAR files. I'm sorry, it's probably end of July. It used to be mid-July, but NAR is delayed when they're going to file this preliminary settlement agreement. And it's 120 days from the date in which they file this preliminary settlement agreement. And there's nothing that says that MLSs have to wait until this deadline, till the end of January. They can make those changes ahead of time. That's up to your MLS to make that decision. There are often questions about, okay, what happens for listing agreements or buyer agency agreements that are existing, that are put in place prior to this time period? Well, after that time period, you will have to amend those existing listing agreements or buyer agency agreements. But you don't have to make the changes until this deadline, which again, we think is going to be at the end of July. Once we know when that agreement is filed, we will have a more clear date as to when you have to make those changes, and we will definitely communicate that to you.
I'm going to throw a question out to Tracy. Tracy, there's been a question posed about would policy letters between brokers be prohibited going forward when it's relating to the offer of compensation?
No, I think that I saw another question about policy letters. What happens to the ones that are already in play? What I'm going to start with is any policy letter or any compensation agreement that you have that is broker to broker, if it is currently modifying an existing offer of compensation in the MLS, well, once the MLS offer of compensation goes away, you're not modifying anything. But there are some standing compensation agreement policy letters that are between firms, for example, with a firm that's in the MLS and a firm that's not in the MLS. So if that's one of those letters that you're talking about, they will continue on because they are not modifying the MLS, they're instead of the MLS. Right. And so I think it depends on the content, it depends on the party. And so that's that. There's another MLS question, if I can, to just talk about. Someone was asking, will remarks sections go away in the MLS? And my answer is probably not, because the remarks section is still where you say, big dog, watch out. Like the things that you need to communicate to each other. You just can't be using those remarks sections as a substitute to offer compensation. So one of the things in the settlement agreement is the MLSs have to eliminate the fields where offers of compensation are being made, right? So those fields, SA, BA, depending on how your MLS calls them, those, compensation fields, those will be gone, but the other fields will remain, but you can't use them to offer broker to broker commission. So, and so those are the couple.
Yeah, just a couple other notes that the WRA is currently working on compensation agreements, broker to broker compensation agreements. We'll have something to you shortly. We're waiting for the final settlement agreement to be filed so that we know that's happening. And then we've already started working on drafts internally that we will share with you so that you have a model agreement that you can use. As always, you're free to have your own agreement drafted by an attorney to use, but the WRA will have that for you. In addition, we will also have some model language to use to amend your existing listing agreements and buyer agency agreements. That's something that we'll likely work with our forms committee on. So just watch for that too. We'll provide you with these resources as we work through them. Talk to our outside legal counsel to advise us on this, and then share those with you when the time is appropriate.
And then just as a confirmation, there was a question. So we can advertise on the MLS seller's agent compensation, but not buyer's agents. Jennifer, is that a true or false statement?
Advertising it on the MLS with the sellers paying to the listing firm?
Says, can we advertise on the MLS seller's agent compensation, but not buyer's agents?
I guess I'm gonna answer the question the way I think it's being asked, where the listing firm is charging the seller some percentage, and then they were going to offer a compensation to a sub-agent instead of a buyer's agent. You can't advertise any compensation that you'd be offering to any agent on the MLS. And all of that will have to be done in a different way, regardless of what type of agent you would be offering that compensation to. So that discussion of offers of compensation, that's gone. That platform is not what we're going to use that for anymore.
Somebody's asked a question about whether this lawsuit is the tip of the iceberg for other future lawsuits and just want us to speculate on that. This settlement agreement is supposed to resolve all antitrust lawsuits involving broker compensation, at least by home sellers. There's still the home buyer antitrust lawsuit that's out there. So no, that's still pending. And there's nothing that prevents somebody else from coming up with some different legal theory to bring against the organization. It hasn't happened in the last during my tenure here, which is almost 27 years, but we'll have to see what happens in the future. I know some have raised concerns about not litigating this further and reaching a settlement agreement. That bad decision by the circuit court judge in Missouri is still on the books and could be used for bad legal precedent against us. So that is a concern. We'll just have to see how this plays out, but just that's something to watch, and that this settlement agreement won't make all lawsuits go away, but it hopefully will resolve the ones involving home sellers related to this broker compensation issue.
Debbie, if I may ask you a follow-up question on your commercial discussion. There's a question clarifying whether if it's a commercial listing on the MLS, can the listing agent advertise compensation to buyers, yes or no?
No.
So
Same
again,
rules apply.
there you go. Yep. Just to, again, if the property is listed in the MLS under the proposed settlement agreement, you would not be able to utilize the MLS to offer compensation to another. I'm scrolling as much as I can if anyone sees. Again, just to reemphasize, this webinar will be recorded and will be posted in the necessary places to make sure that membership is able to see it.
Ooh, I see. They're asking who gets the money, the attorneys, for the most part.
The only winner in class actions are the attorneys for the most part.
They're talking about that the home sellers might get $20 or something like that. I mean, it's if they're lucky.
And if you have any specific questions that are related only to your practice, we would encourage you to contact the legal hotline. We're trying to answer the questions that are more broadly applicable to the entire practice of Wisconsin realtors rather than narrow individual case by case.
And
I just
Corey,
have-
There was one, oh,
I was just
Okay.
gonna say, I just have an administrative one. Somebody said, Tom keeps mentioning December. What is that all about? That is an anticipated date. It's what the expectation is if the settlement is approved, that's when the final approval would potentially take place. And I know we just said potentially proposed 20 times, but that's the world that we're in right now. That's the expectation for NAR's timeline of when, if this is approved, then that would be the final approval.
This, and again, remember, there are two dates to remember. The end of July date, which is the date that these changes have to go into effect under the agreement. So the plaintiffs and defendants entered into this agreement saying we will agree to make these changes by the end of July. They filed this agreement with the court. The court, they anticipate, will finalize this agreement by December. Nothing saying that the court won't change the provisions of the settlement agreement. That is an option. That's why you have not seen any changes in language, changes in forms to us, because we are at the very early stages. This is only a proposed settlement agreement that has not been finalized by the court. It hasn't even been filed with the court yet. It's going to be filed in the next couple of weeks. And then the court has until we think the end of December to approve this proposed settlement agreement. Any more questions about the DOJ, whether the DOJ will throw out this agreement? I think more likely is the DOJ could make some changes to this agreement. Again, this agreement, you see in certain places that it applies only to MLS participants. It can't be displayed in the MLS. The DOJ may look at this issue a little bit more broadly and say it applies to all real estate practitioners, and proposed commission sharing agreements have to be made public, have to be incorporated into buyer agency agreements and listing agreements. You may see something like that from DOJ. We're just speculating at this point. We'll have to see if and how DOJ weighs in on this.
May I answer one more that I've seen come in a couple times here? I've seen a couple people ask if the seller can offer compensation on the MLS, and the settlement says that they have to prohibit MLS participants, subscribers, and their sellers from making offers of compensation on the MLS to other agents. Cannot be used as a workaround. I'm not saying that somebody was trying to use their seller as a workaround, but the sellers can't advertise an offer of compensation on the MLS. It does allow for seller though. So if a seller wanted to make an offer to a buyer for some amount to assist with their closing costs, that could be advertised, but it can't be an offer of compensation to the buyer's firm, regardless of whether who's making it. They just no offers of compensation, regardless of the source on the MLS.
and I think one of the questions that there were a couple questions about discussing compensation with your potential clients, and somebody said, what's the safest way to discuss commission? And I think this doubles back to, It's about showing what your value is in the transaction. Both Jennifer and Wendy have talked about this, to be able to say that these are the services that we provide, and what we do, what the value is that we bring to this conversation, and have a transparent, honest conversation. One of the things in there, I saw someone saying about advertising what their own company is doing for commissions. For those of you who've heard me say this, talk about yourself. Have a Toby Keith moment. Talk about yourself. Talk about me. Talk about I. Talk about number one. Always talk about what you and your firm are going to do for that client. Don't talk about the other guy. Say that this is the value we bring. This is what we do. This is how we negotiate it. And so again, keeping that conversation to yourself, and not about that. So yeah, someone else got the Toby Keith reference. So I appreciate that. So thank you.
Several people have asked whether buyers can ask the seller to pay the buyer's agent's compensation as part of the offer to purchase. Yes, they may. You'll likely see that happen more. And at some point, you could see this as a just an optional provision in the offer to purchase. That's something that would be up to the Forms Council to decide, but that's something that is an option that we're looking at, and I'm sure others will be looking at as well as an addenda.
There's several questions about policy letters. Will those continue to be applicable? Will we have to renegotiate, or as far as get those re-signed? We are still kind of wading through that and figuring out what the potential consequences with that would be. Again, several more questions about different platforms that may be associated with showings. How is this prohibited under the settlement agreement? Some of this will depend on who owns those showing lines. And so again, just not making any commitments, but there is a suggestion that that may not be the right tool that would be utilized under the proposed settlement agreement as it's drafted. And I'm seeing again several questions about agency, again, potentially how this proposed settlement agreement will apply to dual agency, sub-agency, designated agency, all of the types of agencies. We are behind the scenes again looking at the potential impacts the proposed settlement may have relating to our state laws regarding agency, in addition just looking at agency as a whole. So it just gives an opportunity just to look at license law in its entirety. So again, this is just one place that we can focus on with the proposed settlement. It doesn't necessarily mean that there aren't other things that would be discussed. The last question I will take, and I'll let others take some. SB 351, which is the bill that relates to the MLS sales tax exemption. The language does say that it is the MLS is there to facilitate compensation and cooperation. The question is this law going to be revoked somehow? It was signed into law just last week. It will go into effect 3 months from its date that it was signed. Arguably, it is obviously the MLS, as Tracy indicated, is still a place to facilitate cooperation. And then there is still an opportunity to facilitate compensation, if you will, when it comes to the seller's concessions. So we're exploring what the proposed settlement means for that bill. But if it does somehow have a long-term impact, we will then have that on our legislative priorities for the 2025-26 legislative session.
Yeah, I'm going to jump in on another one about commissions. There's a statement that I've heard buyer agent commissions in an offer is illegal and it's not allowed. I'm going to make the distinction here. A buyer in the offer to purchase can always ask the seller to pay a buyer agency fee on their behalf. That's perfectly fine. What cannot be used is the offer to purchase cannot be used to modify a broker to broker commission agreement that exists. Okay, so the offer can't say, hey, listing agent, you have to pay the cooperating agent a different amount of money than what's in the MLS. That is what is a violation of the Realtor Code of Ethics. But in terms of purely asking a buyer, purely asking a seller to say, listen, I would like you to pay this money to pay my buyer's agent, that's fair game. And we will be seeing that moving forward without a doubt. So again, that buyer to seller request is fair game. It's just that you can't use an offer to purchase to try to modify an existing compensation agreement between brokers. So I hope that helps clarify that point.
The other thing that we'd offer, and again, we don't want to spread all of ourselves too thin, but if you have a company meeting, you have a local board meeting, and you'd like us to participate, preferably by Zoom if we could, just so we're not running all around the state, we're happy to do that. Use this as a resource, happy to communicate the message as often as we need to. And please reach out and use us. That's what we're here for. We're a resource. We'd love to talk to you and explain more to your agents, to your colleagues, and yeah, we're available. So please reach out.
And we will continue to do legal update lives as we learn information to help disseminate that out to you. There's nothing that changes the housing inventory. There's nothing that changes the complexity of a real estate transaction, that you cannot offer MLS compensation if the proposed settlement terms go into play, whether it's for a buyer's agent or sub-agent. And we will get our talking points to you soon.
Okay, guys, I think we're going to wrap up here. Again, let us know if you have questions. Use the legal hotline. You can email us anytime, and we'll be back to you shortly whenever we get some more information to share. Thank you.